Sarah Flack is a criminal defense attorney, former prosecutor. Michael Bixon, criminal defense attorney, and Michael Sterling, back with us, former federal prosecutor and defense attorney. I want to start with the second angle that we have now seen over the past day and a half, where you can see the other officers. You can not only see Derek Chauvin with his knee on George Floyd's neck, but you see Officer Kane and Lane also on top, and then Officer Tao just sort of standing there, keeping the crowd at bay and allowing this to happen. Sarah, to you first, when you look at that video and you look at the other officers, their role in this, do you expect, I know the family does, do you expect charges, and how serious of charges do you think that Keith Ellison, who's taken over this case now, Minnesota Attorney General, can go with? How serious can these three, at least two of them, be in terms of how serious can the charges be against them, do you think, and should they be?
Well, those are two separate questions, Ted. Should they be? Absolutely. They're complicit in what happened. If they were four gang members standing outside and one person is putting their knee on a victim that they just robbed and the other three are attacking them, they would all be charged as parties to a crime. So I do think they should be charged with murder. Do I think, or your question was, do I expect them to be charged? Well, as a lawyer, I have to look at the facts. I have to look at historically what has happened in this system. And so do I expect them to be charged? Absolutely not. In fact, I don't expect that the officer himself will be convicted of anything. If we look at, again, historically and precedent, which is what I as a lawyer have to go off of.
And is that because you think that the police officers inherently are difficult to convict in a court of law because jurors give them a different weight, and we do as a society? Is that the reason, or is it something else?
No, I don't think that that's it. I think that unfairly takes the pressure off of what the real reason is. The real reason is the laws are set up that way to protect officers. And so if the laws don't change, certain things, even civil liability, qualified immunity, if we continue to have those protections in place, officers will be free to continue, running about like the Wild Wild West, which is what we're seeing in this video. And also why that officer was not at all scared and looked dead in the eye of that camera, wasn't concerned at all that the public saw what was happening, because he knows the protection he has as an officer.
Yeah, Michael Bixon, that is a very concerning part of this equation when you see both those officers, Officer Tao, too, just standing there as this, George Floyd dies, and people are horrified, saying, do something, do something. Neither one of them not only do anything, but there seems to be this attitude of like, hey, we're doing what we're doing. This is do you expect the others to be charged, Michael Bixon?
I think they should be. I think they're parties to a crime, and I think this is murder. It's that simple. And I completely agree with what Sarah said. If this were anybody else, they would have already been charged, But the problem is that they are afforded all these extra protections under the law that the average citizen is not. It's not just that the juries, don't want to convict a cop. They're actually given extra protection under the law being an officer, and it makes it that much harder to convict them. Usually prosecutors are a lot more reluctant to bring forth charges against officers knowing that. They don't want to bring forth a case that they're going to lose. Now, I do think it's certainly possible that these officers are going to be charged, and I think they absolutely should be as well.
Michael Sterling, should the laws change because of that, or should prosecutors become more aggressive? Does there need to be something formal, or can there be a change using the existing laws that do protect police officers, in some cases for very good reasons?
Both. Prosecutors need to become more aggressive about going after rogue police officers. I mean, the one thing that stands out to me in looking at this was that he was obviously in handcuffs and in the car at one point. So you're telling me that 4 police officers who are trained in hand-to-hand combat, who have guns and tasers, are in a struggle with a man who's handcuffed behind his back, and they believe it's necessary to kneel on him, 3 officers to put their full body weight on him and kneel on him for more than 9 minutes, and that's not a crime. It's just not believable. It's not credible that at the point the threat was eliminated, even if you felt that there was threatened, that Officer Tao couldn't have just tapped Officer Chauvin and said, hey, let him breathe. This is a betrayal of the public trust in the worst way. You swore an oath to protect and to serve. You swore an oath that you would uphold the Constitution, that you would help people, that you would protect the public safety. What this is this is a gross abuse of power. So yes, the laws have to change on qualified immunity. The laws have to change on sovereign immunity so that cities can be held accountable in certain states. And prosecutors have to be unafraid to go after bad cops, because bad cops make all the other cops vulnerable, they put a stain on the idea of policing. And if you're not going to be aggressive about going after these bad cops, if you're not going to be aggressive about doing it, then you should move out the way and let somebody become a district attorney who is going to do it.
Sarah, as a former prosecutor, how much pressure was there when you were a prosecutor, and is there systemically in the system now pressure on prosecutors not to touch police officers? And do you think it's playing out in this case, or do you think this case is so big the pressure is actually the other way, where there's pressure to file charges?
Well, I do think there's pressure in this case. I mean, I've never seen the support from, really every walk of life as I have in this case. I will say, when I was a prosecutor, my office, I was fortunate enough to be in an office that had a separate unit that just handled, it was called public integrity, that only handled the indicting and charging of public servants. And their office was actually strategically across the street. It wasn't even in the same building as ours, to sort of keep that separation, because quite naturally, as a prosecutor, I had officers' cell phone numbers and we would text whenever cases would happen. So you naturally become close and become friends with these officers, and a lot of them are wonderful. But so you think about a small town where you only have one or two prosecutors and they know every single sheriff, and then, the sheriff gets charged with something like this. How on earth can anyone have any certainty that prosecutor is going to do the right thing? I mean, human nature, that's your friend. That's somebody you give the benefit of the doubt to. So no, I don't think, I think normally that's why you see the lack of prosecution from prosecuting offices, because of that conflict of interest.
Michael Bixon, Tu Tao, the gentleman who's standing there, who does not have his hands on George Floyd during this situation. Many people here on the panel, we've heard it tonight, we heard it last night. They think he's complicit as well because he's part of this group during this incident. But will a jury really convict him? I mean, would charging him result in a conviction? Because you're expecting him to be able to figure out that George Floyd is in distress while you're not actually monitoring the entire situation. You're not as close as the other two. What's your take on Officer Tao? Is he as culpable?
100%. And I think it depends on how you frame the case. If this were anybody else, if these were not officers, they would just say, he's the lookout. He's a party to this crime, and he is just as culpable. Was his knee on him? No. Was he holding him down? No. But he was the lookout while this crime was being committed, and he did nothing, not only to stop it, but he prevented people from interfering in saving this man's life. He absolutely should be prosecuted. It's that simple.
All right, we're going to take a break. When we come back, we're going to talk about the two autopsies. One performed by the Hennepin County coroner, another performed independently. The differences, the similarities between them, and the importance of having two. We'll talk about that when we return.
Certainly, each of us has concluded that on the basis of all the information available, the cause of death is what was seen at the time of the death. He couldn't breathe, asphyxia due to compression of the neck and of the back, and that's homicidal.
Welcome back. That is Dr. Michael Baden, who helped perform the private autopsy on George Floyd, paid for by the family. Now, both the Hennepin County medical examiner and the private autopsy concluded that the manner of death in this case is homicide, but there are some very distinct and crucial differences. Ashley Banfield spoke about that with forensic expert Professor Lawrence Kopolinsky from the John Jay College of Criminal Justice. Take a look at it.
First report by the Hennepin County Medical Examiner's Office indicated that there was no physical evidence of traumatic or mechanical asphyxiation or strangulation. In other words, they did the autopsy. They didn't find any evidence of broken cartilage in the neck or bone, the hyoid bone being fractured. No specific evidence like that, because had they had that, they would have drawn a different conclusion. The second autopsy, on the other hand, indicates that this was a mechanical asphyxiation, and it's based on pressure to the neck and to the back, which is obviously seen in the videotape.
But how does that happen? I mean, if you have, look, Dr. Bodden is, the former New York representative. He's no slouch. How do you get two completely different results?
Well, this is not necessarily science. It's really medicine, which is an art mixed in with science. You can't reproduce what you're testing. And so you have to draw your conclusions based on one's skills, knowledge, experience, and training. And so Dr. Bodden's a very experienced medical examiner. So, we have to listen very carefully to what he says. But the issue, I think, is whether or not there is physical evidence in the autopsy itself as to whether or not there is a mechanical or traumatic asphyxiation, which is the major difference in the two.
Still with me, all three of my guests, Michael Bixon, Michael Sterling, Sarah Flack. Let's start with just the idea that this autopsy was performed so quickly. A lot of times autopsies are done by either defendants or lawyers representing defendants in civil cases, other interested parties, but there's typically time that goes by and jurors don't necessarily equate them with the autopsy that was done by the medical examiner. These were basically within days of each other. How important was that moving forward in both criminal and civil litigation? Sarah, to you.
Ted, I really don't know that it's as big of a deal as we're making it out to be, only because we've seen the entire murder happen on video, which is very, very rare. I think had it not been recorded and had we not seen it, then it would have certainly made a difference in terms of, did he die from some other cause or did this at all contribute to his death? But honestly, I mean, if there's a question at trial and closing, you can guarantee that the prosecutor is going to say, look, if you've got a question about it, jury, just go back to this video.
Well,
Watch the video as many times as you want.
What about the guy in the jury that's saying, well, I heard him talking. He must have been breathing. This second autopsy says asphyxiation is the cause of death. The first one didn't. The manner is homicide, but the first one didn't. Doesn't it help, at least to that point, to answer that juror's potential question of, well, how could he have died from asphyxiation if he was talking?
It does, but I mean, legally, even if he didn't necessarily die from that, but there was let's say he had a heart attack, you still can make the argument that that contributed to his manner of death. And I think there's no question that even if it was something different or the discrepancy, that still the police officers contributed in a very, very large way to his death and were ultimately the cause of his death. I just don't think it's that big of a deal.
Michael Sterling, how do you think the autopsies in general will factor in during the? Let's start with just the criminal trial of the one that we know is likely coming, unless there's a plea deal with Derek Chauvin.
Well, I think the first thing you have to consider is that both of them came to the conclusion that this was homicide. I think depending upon, I think the autopsy may play a role in determining whether or not the charges get upgraded. Certainly, the prosecutors are probably asking Attorney Crump to review the autopsy so that they can make a determination about whether or not to upgrade the charges, probably from third-degree murder to something higher. And so I do think that a lot of times when you have two expert witnesses who say something different, that they could potentially cancel each other out. But the fact that both of these reach the same conclusion in different ways, I'm not certain how much of a difference it will play, except in determining whether or not the charges are upgraded and whether or not the jury convicts on on a higher charge or not, on a more severe charge, rather.
Michael Bixon, what is Derek Chauvin's defense going to look like?
It's going to be tough. I think it's really going to revolve around him acting in his official duties. It's going to come down to the stresses that he deals with on a daily basis and all the other aspects of being a police officer that might have led to this. And obviously, he's going to say that, look, this is not something that he intended to happen. I think that the first medical report does help him. I don't think it's going to exonerate him by any means. I do think the second medical report is very, very bad for his case. But a lot of this is going to revolve around him acting in his official police duties. At least that's going to be his argument. And I think it's going to be a very, very hard argument to make, because when you watch that video, it goes on for so long. And the amount of force that is used is so excessive by any standard, by any definition. And it's hard not to watch that and cringe and feel anger. And I think the jury is going to see that, and they're going to feel that, and it's going to destroy his defense.
Sarah, do you agree, or do you think that this is not necessarily a slam dunk, even though the video is there and the jury will see multiple angles?
No, I do think it's a slam dunk. I mean, this is just one of those cases, I think the only case we've ever seen that no matter what angle you look at it, you just can't get around the length of time that happened, and you see it all. I just don't think that this is a case where the jury would get hung up on some of the technicalities, which they normally do in law enforcement peace officer cases.
Michael Sterling, slam dunk at third degree. What about first degree, if that's where this ends up after Keith Ellison potentially, if he moves up the charges and makes it a first degree case?
It's not a slam dunk, unfortunately. We saw, for example, in the Walter Scott case in South Carolina, there's a video of an officer shooting a man running away, which has been outlawed for many, many years, particularly when there's not another danger present. We saw a police officer shoot Walter Scott in the back several times, and a state juror acquitted him, I believe, and then he ended up getting prosecuted federally and then was convicted. So unfortunately, these cases are just never a slam dunk when it comes to police officers. And so the prosecutors will just have to present the very best case they can. I do think the video certainly helps. As we were watching it, I had to fight back tears just seeing his body go limp, and the police officer just keeping his knee on his neck. It's depraved. I don't know what else to say, but it's depraved. It's inhuman. And I don't know how you could do that to another person, especially as a police officer.
As powerful and disgusting a video I think anybody could conjure up in that type of situation. Michael Sterling, thank you for being with us tonight. Michael Bixon and Sarah Flack, you're going to be returning. When we come back, we're going to switch gears, and we're going to talk about Scott Peterson and his opportunity to present his appeal to the California Supreme Court. It happened today. We're going to get the details from Beth Karras, special contributor to Court TV. She monitored all of the arguments and is going to join us live. We'll talk about that when we return.
There are no mandatory death penalties. In a state like California, jurors are presented with aggravating evidence, and they're presented with mitigating evidence. And they're asked to make a choice. Sometimes jurors choose death. Sometimes they choose life without parole. Put another way, in the terms that juror 6960 used, life without parole is good in some cases. The state is seeking to discharge this juror not because she would not follow the law, but because she would.
That was Cliff Gardner representing Scott Peterson in his appeal to the California Supreme Court. Oral arguments were heard this afternoon in California, 15 years after Scott Peterson was found guilty and convicted and sentenced to death for the death of his wife Lacey and unborn son Connor. Someone who was there during that time, during that trial, was also monitoring the arguments today. Familiar face to Court TV viewers, contributor Beth Karras. Beth, great to see you. What happened today in front of the justices? Give us your overall feel of it, and just your take on this appeal so long in coming.
So there were several issues that are actually pending before the court to justify either at least a new penalty phase or a new trial altogether. But the argument focused on three. The soundbite you just played deals with jury selection. And Cliff Gardner, who is an excellent attorney, excellent appellate attorney, and Scott got the best. He focused on 3 jurors out of 13 they really took issue with, not jurors who sat in judgment in the case. They were dismissed based upon answers in their questionnaire without any opportunity for either side to actually question them and try to rehabilitate. Sometimes you try to rehabilitate a potential juror based on things that they may have said that don't favor one side. So the defense wanted these jurors who were opposed to the death penalty, but the judge is like, no, you're out of here. Cliff Gardner made very good arguments on that, and the state's response to it was, we stand by what the judge did. The judge was very experienced in death penalty cases. He knows the law. He knows the standard for dismissing jurors. We stand by our arguments in our briefs. But if you find that there is error in any one of the, not just the 3 argued today, but any of the 13 jurors the defense took issue with who were dismissed, then the remedy is a new penalty phase, not a whole new trial on the guilt. This does not go to guilt. These were just jurors who maybe wouldn't have voted for the death penalty. And I'll tell you right now, my prediction is that Scott's going to win on that point. His conviction stands. He remains guilty. He will get life without parole. That's my prediction. He'll get, if this court is leaning, at least 4, they have to be 4-3 for a decision, at least 4 thinking, yeah, there was some error in jury selection. So
let's
he gets life without parole.
Let's listen to some of that exact argument you talked about by Scott's attorney, Cliff Gardner.
This juror said that she was opposed to the death penalty. Opposed, not strongly opposed, opposed. They had 3 options: weakly opposed, and strongly opposed. This juror was simply opposed. In answer to question 115, however, she said her views would not preclude her from imposing death. And the court discharged this juror saying, quote, "I'm going to exclude 6960 for cause because that juror is opposed to the death penalty without reservation." The state defends that ruling and argues that it has carried its burden of showing that there's, quote, "no doubt," and that the juror questionnaire made clear this juror would not follow the law for 2 reasons. They focus on 2 additional answers in the questionnaire. One, they focus on the fact that this juror, when asked about the death penalty, said, quote, "I wish it was not something we needed," end quote. Second, when asked about her opinions on life without parole, she said, quote, "It's good in some cases," end quote. And the state argues that these answers show that this juror leaves no doubt that this juror would refuse to follow the law.
With respect to jurors in this case, there is no credible claim in this appeal that any one of the 12 jurors that heard that evidence was anything other than fair and impartial. The 12 citizens of San Mateo County who were carefully selected for this case swore an oath, Your Honors, to be fair to Scott Peterson, to the people as well. And the record demonstrates that the jurors, each and every one of them, kept that promise.
Beth, the other 2 issues, the boat, and talk about change of venue as well.
Yes. Okay. So there was a boat demonstration that the defense wanted to get into evidence, and the judge didn't allow it. But yet, during deliberations, when the actual boat was introduced into evidence, jurors, saw the boat, and a couple of them stepped inside it, and they objected to that. So the boat thing was two-part. The judge didn't let in the demonstration on the water, rightly so, because you cannot replicate exactly what happened that day, right? I mean, it wasn't the actual boat, and you can't replicate the size, the weight. You don't know exactly, what happened in the conditions that day, the weather conditions, right? So that was a right decision. I don't think there'll be a problem. I don't think there'll be any change in that ruling. Regarding what the jurors did they do their own little demonstration? Because they got in the boat and a few of them rocked it. There was an objection. The judge immediately gave them an admonition and said, that's not the same. On the boat trailer, the stability of the boat, it's different on the water. And the state, or they're the respondent, in this case, the Attorney General's office argued today, look, that is actually an admonition to the jury during deliberations that was helpful to the defense, one could argue. And then the change of venue, also, in my opinion, not a winner for the appellate, for Scott Peterson. but the state did say, look, you know, the defense didn't even ask for this second change of venue, because we know it was tried in a different place, about 90 miles from Modesto, which is where I first met you. And after 66 jurors were passed and agreed to 4 times by the defense, you know, to be the final pool from which they would get the sitting juror, then he makes another motion to change the venue to Southern California. And the Attorney General's office just now said, well, wait a second, like, he didn't take issue with any of those 66. He approved those 66 4 times during the course of the several months it took to get a jury. It did take several months. And so it's almost like he's made a motion too late. But where could they have tried the case? It would have been maybe fairer. The defense argues downstate somewhere, maybe in Southern California. However, I don't see that as a really convincing winning argument. And the cases that the Attorney General's office cited for where a reversal is justified include the Sam Shepard case, which, just to give you a little history note here, was argued on February 28, 1966 in the United States Supreme Court on the same day as Ernesto Miranda from Miranda Rights. They were argued the same day. Sam Shepard, represented by F. Lee Bailey, did get a new trial, but his case really was a carnival atmosphere, not like Scott Peterson. Cameras were not allowed in the courtroom, and it wasn't the same, you know, it wasn't the same kind of publicity inside the courtroom. Jurors were sequestered, something that came out of the Sam Shepard case, by the way. Sequester jurors if you're worried about publicity, and that's what they did. I think that the change of venue is a loser. I think the vote demonstration is a loser. But I think that the jury selection could be a winner for Scott Peterson. But just that it'll get him a life sentence, not a new trial.
Let's take a listen to the arguments surrounding the change of venue.
We really don't have to draw any subjective judgments on this, because jurors were asked, having been exposed to this publicity, can you keep an open mind? How many of you have formed an opinion as to guilt or innocence? And nearly 50% of the jurors questioned in court who were filling out questionnaires said they had already reached an opinion as to guilt or innocence. Now, keep in mind, this is not a telephone survey. This is people who are come to the courthouse and they are faced with the solemnity of court proceedings. And they, like all American citizens, know that their role is to set aside what they've heard and decide this case and be fair jurists about it. Notwithstanding that knowledge and notwithstanding the solemnity of the proceedings, nearly 50% of those jurors said they had already reached a decision before hearing a single witness. Now, even that doesn't necessarily justify a presumption of correctness, a presumption of prejudice, because maybe the press was balanced and maybe 50% of them thought he was innocent and the other 50% thought he was guilty. In fact, when we look at the data, we see that of the nearly 50% that had reached a decision, 98.5% thought he was guilty, and 6 jurors thought he was innocent out of the 1,000 that had completed questionnaires at the time the change of venue motion was raised. So there's really no doubt about the pervasive nature, there's no doubt it was adverse, and there's really no doubt about whether it was influencing jurors. It plainly was.
There is no evidence appellant presented that he would have fared better not just on recognition and publicity, but also on prejudgment. And the other point, to Justice Clare's point about conducting the surveys in a certain time frame, respondent would suggest that conducting it a year ahead of the time that the second motion was made would be closer in time to when the bulk, if you will, of the publicity actually occurred in this case. Because the experts, I believe, agreed that there was an ebb and flow to the coverage in this case. And most of the coverage, understandably, occurred when Lacey went missing. And so by the time we got to trial, there had been basically an ebb in the publicity. And so therefore, my suggestion, Your Honors, is that those surveys were highly probative when the publicity was at its highest. And as the trial judge, I think, said here, the only place that this case could have gone where no one would have heard about it was Mars.
All right, so bottom line, Beth, you believe that the best case for Scott Peterson here is the same one that Cliff Gardner believes is his strongest argument, and that is that there were 13 of these jurors that came in, filled out this questionnaires, and in some cases said, yeah, they were open to following the law, yet they were dismissed. That was a mistake by Alfred DeLucchi. The prosecution asked for it, and Judge DeLucchi let them go. Now, you made the point that there are two choices here, and the case law basically says that if this happens, yeah, the death penalty now should be off the table and it's life without parole. Cliff Gardner wants to take a next step. He believes that case law is old and that the Witherspoon is the case that is sort of the prevailing one here. He says that's too old. This needs to be revisited. Do you think there's a chance that he has an opportunity?
Well, I guess there's always a chance that 4 of the justices will agree that Scott Peterson deserves a new trial, that it was unfair, and he deserves a new guilt phase of the trial. But I personally don't think that that's going to happen. I think that it will just be a reversal on the sentence, if that at all. Some jurisdictions may not have even sought death against Scott Peterson if this had happened in another death penalty state or another county. Who knows? It's a judgment call of the prosecutor. So, people vary on what deserves death. Most important for the victims in this case is the conviction, right, for murder, that he never be free again and that he serve a sentence for the murder. But I do, I don't know how long it'll be, but that's what I think will be the outcome. Or I think that's the best shot that Scott Peterson has.
All right. Beth Karras,
but I just want to,
go ahead.
If we have time,
Go ahead,
I just want to say that Cliff Gardner did make a very good argument, though, that when you get a death qualified jury and you make sure that all the jurors are rah death penalty, that they're more likely to look at the guilt phase evidence in a light more favorable to the prosecution. And he felt that, at the guilt phase, the jury was denied the other voice of people who are opposed to the death penalty and hence might look at the guilt evidence a little differently. I just want to get that in there because that was a good argument.
Yeah, absolutely. And it is a good argument. We've seen it a lot of, I'm a skeptic. I think sometimes prosecutors go for the death penalty even though they know they're not going to get it on the back end, so they'll have a death qualified jury for the guilt phase.
Shouldn't do that.
That's just my opinion.
Right, but it's not good.
Beth Karras, thank you. We're going to have more of this when we return. You're watching Court TV, your front row seat to justice. Stay there.
The prosecution marshaled and presented a mountain of evidence that pointed the finger of guilt squarely at Scott Peterson as the murderer of his wife and their child. There is no contention in this appeal that quantum of evidence was legally insufficient, because it wasn't.
That's Donna Provenzano. She is representing the state of California, saying Scott Peterson does not deserve a new trial. That was from earlier today in front of the California Supreme Court. The 7 justices hearing oral arguments via Zoom, as that is the way things are, at least for now. Joining me still with us, Sarah Flack, criminal defense attorney, former prosecutor, and Michael Bixon, criminal defense attorney. First, just get your feelings. Sarah, to you first. You heard Beth Karras sort of characterize what happened today in front of the justices. Appeals are tough. What's your take? Does Peterson have a chance here?
You're right, Ted. I mean, appeals are tough. However, I think in that world, the best chance you have is if you do have a death penalty case like this, because death is different, as we say, in the legal field. So I do think he has at least 2 pretty good issues. Now, whether or not that's enough to sway the court, I don't know. Quite honestly, I don't think that it will be, but I do think that he has some pretty good legal issues in terms of at least the jurors that were excused prior to questioning, and so they never even had a chance to be seated on the panel. So we'll see.
Michael Bixon, your take?
I think the number one issue for Mr. Peterson was the jurors that were excused when they shouldn't have been. I think there was a very good chance that they could have been rehabilitated, and I think that that really could have made a difference in the outcome in terms of whether or not he actually got the death penalty. I think that's going to be the number one issue going forward for him. And I think that there is a chance, how big of a chance I certainly don't know, but I think there's certainly a chance that the court might side with him on that issue alone, really just that one, and they might actually reverse the death penalty. He's still going to be doing life, but I think that one issue, he's got a good shot at it.
It would be a safe decision for the court to make. One of the other issues that Beth brought up, and it is something that the defense thinks is very important, is this boat evidence, that they were not allowed to bring in their demonstrative, this video of one of their attorneys on the boat trying to replicate what happened. And the idea is you cannot throw a 160-pound person out of a 14-foot boat on the San Francisco Bay. It'll capsize. Let's take a listen to that argument.
Jurors asked to see the boat. There was no objection. The jurors were permitted to see the boat. And what happened then was that several jurors, at least two, defense counsel says, the prosecutor says two, got in the boat and they rocked it back and forth. They performed their own boat stability demonstration. Defense counsel objected and placed on the record his objections, and the court ultimately ruled that this was not an improper demonstration. Now, we agree on the question, colleague from the Attorney General's office and I, we agree on the appropriate question. And the appropriate question is whether this experiment was, quote, within the lines of offered evidence, end quote. The state says it was, I say it isn't. Here's in a nutshell why I believe it isn't. And that's this. There was an inference that jurors were seeking to draw. They knew that this offense occurred in the open water. Or this, under the state's theory, the body was tossed off the boat in the open water. The jury was well aware that stability in a garage on a trailer was not the same as stability in the open water. They were trying to draw an inference from the stability on a trailer in the garage to what stability would be like in the open ocean. And that inference, simply put, was not within the lines of offered evidence. And that's immediately why defense counsel objected and said they've taken new evidence. There's a problem here. And ultimately the court said, no, this isn't an improper jury experiment. I believe it was an improper jury experiment precisely because it was not within the lines of offered evidence.
That was the second half of the boat argument, is that not only they didn't get their video in, but then jurors during deliberations were able to get in the boat. And the defense says conduct their own experiment. Does this one stand out to either one of you, Sarah, to you first, as being a legitimate argument? Because it does seem inappropriate to allow jurors to get up there and actually rock the boat back and forth.
I mean, it does seem inappropriate, but I just think when you look at the legal standard, is this really the thing that would have changed the outcome in this case? I'm scratching my head trying to, and I'm a defense attorney. I don't know that this is going to make that, because the standard is, would it have made a difference? Would it have swayed the jury? Was it that prejudicial? And I'm not really following that one, Ted. I don't know that this is going to be the issue that, reverses things or gets him resentenced. I just don't think so.
Michael, the boat, does that hold water, if you will? No pun.
Look, I'm inclined to agree with Sarah on this. I don't think that it's going to be that much of a material issue to really make a difference in the case. I don't think that this is going to be the deciding factor by any means whatsoever for the court. Do I think it was improper? Yeah. I think the court still explained to the jurors the issues with it. At the end of the day, I don't think this is going to make that big a difference. I still think this is going to come back to the issues that we already discussed, namely the jury selection. This, though, by itself, not really.
Yeah. Right. Well, we'll have to wait and see. Of course, when a Supreme Court hears oral argument, it's only part of the equation. There's also a 500-plus page brief that was sent as part of what the justices will mull over, and it will take some time. We expect a decision over the next few months. And then there's the habeas, which is a whole other track, which Scott Peterson has also filed. That will also be at some point adopted by the California Supreme Court and eventually possibly the U.S. Supreme Court, depending on how things go. I want to thank Sarah Flack, criminal defense attorney, former prosecutor, and Michael Bixon for being with us this evening. Thank you both. Appreciate it. A lot to talk about today and tomorrow and the next day because we are going through so much. We'll be back here tomorrow night, 8 o'clock Eastern Time, 8 to 11. We're here every weeknight on Court TV. Thank you for joining us. We'll see you tomorrow night.